to the big focus story at this hour. Delivering a significant judgment on the powers of money laundering, the Delhi High Court made it clear that when it comes to probes of the Enforcement Directorate, the agency is not free to probe independent offences. The single judge bench of the High Court said that ED will have to restrict its probes to laundering offences and cannot take up probes outside its remit under the scheduled offences. The High Court says, and I quote, if we can put that out on our screens as well, please, what needs to be emphasised is that the PMLA empowers the ED to investigate Section 3 offences only. Its power to investigate and inquire stands confined to the offence of money laundering as defined in that section. Now, what does the section say? This is what it says, if I may just quote it ad verbatim. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime and projects it as untainted property shall be guilty of the offence of money laundering. So this is the section that the Enforcement Directorate is restricted to. It means that other associated offence will have to be probed by authorities that have been empowered by law. And if ED comes across any incriminating evidence during its investigation, it will have to furnish the information to the concerned agency for further action, not take up probe in that direction on its own. So this is an important order that has come in. I am now joined by Mr. Aryama Sundaram, Senior Advocate, is with us here on the program. Very good evening, Mr. Aryama Sundaram. Thanks for joining us. First of all, if you can break it down for us a bit for easy understanding for the citizen, what would this mean?
Well, very simply put, the PMLA Act, which was to guard against money laundering, in other words, to ensure that monies gained out of illicit activities were duly chased, found, and dealt with in accordance with the Act, came to be challenged. And the Act was challenged before the Supreme Court, and the Supreme Court upheld the constitutionality of the Act. But while upholding the constitutionality of the Act, the Supreme Court also clearly interpreted various sections, the roles and powers of various authorities, including the ED. Now, unfortunately, the ED appears to have got fortified by the larger picture of the Act having been upheld and thereafter arrogated to itself powers that it does not have at all. Now, the ED has been doing so in a number of cases. There are cases all over the country on which these issues are arising. I, for one, know about a matter before the Kolkata High Court. There are other high courts which are similarly seized of the matter. I think the judgment of the Delhi High Court today was a very, very, very clear exposition as to what exactly the ED's powers were, right, and where the boundaries of their jurisdiction were very clearly defined and what they cannot cross. And in doing so, the Delhi High Court has taken from the judgment of the Supreme Court itself in upholding the PMLA Act while laying down various caveats. And let me tell you in a nutshell what the caveat is. The Supreme Court has very clearly said that for a PMLA action, there has to be an underlying offence. In other words, there has to be what is called the predicated offence. That is to say, somebody has committed an offence falling under the IPC or other provisions of law. Right. And if such an offence has been committed, then the PMLA springs into action. So the PMLA and Section 3 and other provisions cannot spring into action unless there's an underlying predicated offence. Now, the Supreme Court has gone on to say that such predicated offence must be a live offence, not a case of an offence which has been quashed, or the person acquitted, or discharged, or where there is no FIR at all. Now, in such a case, the ED cannot say, in my view, there is a predicated offence, and acting on an assumption that my inquiries and investigations show that there is a predicated offence, I will therefore act under the PMLA Act. Now, the Supreme Court has also taken care of that very clearly by pointing out sections of the Act which clearly say that if in the course of their investigations, the ED come across the committing of any offence, they can then send it to the jurisdictional magistrate or the jurisdictional police officer, who will thereafter investigate the matter and, if necessary, file an FIR and thereafter proceed. But without such an FIR, without such a live proceeding or a live investigation or inquiry starting from the FIR stage till the proceedings come to an end, the PMLA Act and Section 3 cannot be invoked by the ED. Now, the ED being restrained in this manner, and their jurisdiction very clearly being curtailed in this manner, now are seeking to usurp to themselves powers they do not have, and powers which are totally contrary to what the Supreme Court had said. And the powers that they seek to usurp for themselves is this: look here, I want to proceed under Section 3 of the PMLA Act. I know I cannot do so unless there's a predicated offence. So let me thereafter, from the materials I have, work on the assumption that there is a predicated offence, work on the assumption and investigate what I believe is a predicated offence. And since I believe there is a predicated offence, since I assume there's a predicated offence, let me therefore invoke Section 3 of the Act.
So let me make it very clear,
The Delhi High
Mr.
Court,
Sundaram,
I think, in an excellent judgment,
it is, and the way you are
has made
explaining
it very
to
clear
us
that it cannot do so.
Yes, if I understand it correctly, you are telling us that the High Court has clarified when PMLA can be invoked in the first place, and that itself clears out a lot of things.
Absolutely.
And also you are saying that the ED has in the past, are you saying in a way that the ED has in the past usurped powers that it does not have, and after this order, it has been duly warned not to do so?
Absolutely right. It has usurped the powers like they did in this case before the Delhi High Court. And I think the Delhi High Court, in an excellent exposition of the law, I would use the word excellent exposition of the law, has pointed out how the ED cannot do this. And I think we have a definite pronouncement in a specific case. You see, the Supreme Court had demarcated the jurisdiction of the ED. Now, the Delhi High Court has dealt with a specific case where the ED has arrogated to itself powers it does not have, and has stopped them and said you cannot do so. And to that extent, I think it's a very, very important judgment.
Yes, it is. Thank you so much, Arima Sundaram, for joining us here this evening, giving us a very clear understanding and a clear perspective on how the High Court has curtailed the Enforcement Directorate from certain powers that it has been using, which it is not mandated to. Thanks very much, sir, for giving us your time.